Yes.
May I please the court?
Yes.
VO. VO. Amanjoy. Amanjoy is spelled AMA
Yes.
JUOYI.
Yes.
With me, my lord. I
Yes.
Ichegbo. Ichegbo is spelled ICHEGBO. And SK Ogo. OGOR for the defendant.
Ichegbo and who?
SK
And
Ogo.
who?
SK Ogo.
SK Ogo.
OGOR.
OGOR.
Yes, my lord. Yes, my lord. The most grateful for the defendant.
Okay. This matter is for judgment. The judgment will be read virtually shortly. Yes, this is the judgment of the court. The claimant commenced this suit via a general form of complaint filed at the registry of this court on the 2nd of November 2020. With the leave of court, the claimant amended his complaint and the accompanying processes. The amended complaint was filed on the 18th day of February 2022 and filed on the same date. In the amended statement of facts, the claimant prays for the following reliefs. They are: 1, a declaration that the claimant is entitled, a declaration that the claimant is still an employee of Mobile Producing Nigeria Unlimited, in bracket defendant. 2, a declaration that the claimant is entitled to all his salaries and entitlement up to date, particularly the sum of 47,275,884,856 naira, being the bulk of his 21 years and 10 months unpaid salaries, allowances, medical expenses, and other entitlements, and outstanding amounting from October 23, 1996 to July 13, 2018. 3, a declaration that the act of the defendant's neglect of the claimant, who was exposed to danger and as a result contracted acute chronic carbon monoxide poison with multiple conditions pending kidney failure and pulmonary collapse, among other ailments, in the course of his duty, to say the least, is callous, inhuman, and condemnable. 4, a declaration that the defendant was negligent in his duty owed to the claimant for not providing him with the correct, proper, acceptable, and or approved personal protective equipment and safety gears contrary to its safety policy, which failure resulted in the permanent industrial injury and permanent incapacity he suffered at work and worsened at the location he was posted in the Bonny River State by punitive transfer. 6 and 5, an order directing the defendant to fund the claimant's follow-up trip to the United States of America to continue proper expert medical care and check up to complete his treatment to preserve his life. 6, the sum of 10 billion naira only as general damages. 7, exemplary damages in the sum of 500 million naira. And 8, the sum of 10 million naira only being cost of litigation. The defendant filed his statement of defense and witness statement on oath on the 21st of day of March 2022. Upon service of the defendant's statement of defense, the claimant filed a reply to the defendant's statement of defense on the 28th day of March 2020. However, the said reply to the defendant's statement of defense I think counsel, due to time factor, I will skip all these preliminaries. I will skip all these preliminaries. I will skip reading the case of the claimant, the case of the defendant, the submissions of the defendants, the submissions of the claimants, and go straight to the decision of the court. Because the judgment is bulky, if I have to read everything, it will take time. So let me go straight to the decision of the court. When counsel collect the hard copy, they will have opportunity of reading the preliminary aspect of the case, that is the submissions of counsel and the summary of the case of the claimant and the defendant. I go to the decision of the court. I have considered the processes filed by the parties, the evidence laid by the parties at the trial, and the written and oral submissions of counsel in adumbration. There are 8 reliefs being sought by the claimant as per his amended statement of facts. The law is well settled that claim before the court is circumscribed by the reliefs being sought by the claimant. See Gabriel RTB versus Kabel Metal Nigeria Limited. And grant what was, and the court is entitled to grant the claim as spread by the claimant, but does not have the power to grant more than what was asked or to grant what was not asked before the court, as the court is not Father Christmas dishing out and solicited gifts. In determining the claim of the claimant, this court will confine its step to the consideration of the reliefs being sought. However, before delving into the determination of the claim of the claimant, I shall first and foremost determine issue of admissibility of certain documents to which objection was raised in the course of the proceeding of 29th day of March 2022, when counsel for the claimant applied to tender certain document in evidence. Counsel for the defendant vehemently objected to admissibility of some of the documents sought to be tendered through CW1. After taking argument for and against the objection, the court admitted some of the document in evidence, rejected some, and some others, and ruling on some others was reserved till the day of judgment. And counsel were also given leverage to file argument for and against the admissibility of the documents, and also the way to be attached to the document. From the record of the proceedings of 29th day of March 2022, the remaining documents for the court to consider their admissibility after those admitted and those rejected are as follows. Letter dated 21st day of May 2018, titled Letter of Acknowledgement, photocopy of a letter dated 22nd day of July 2018, titled Respite Police Case Implementation of Supreme Court Judgment Ultimatum to Recall and Duly Sacked Employees. The next is the document titled Salary Allowances Categorized Computation Benefit of Epion Afangide, in bracket October 23 to 1996, well, October 23, 1996 to July 13, 2018. That is 21 years, 10 months. Then the next is document AAOA application to rent. There is also medical reports, bills, and other sundry cost bill and traveling documents. I shall proceed to consider the admissibility or otherwise of this document and were to be ascribed to them if necessary. Regarding letter dated 21st day of May 2018, titled Letter of Acknowledgement, the objection to this is predicated on the alleged forgery. The counsel for the claimant disagreed and argues that the letter is original and that was how it was given to the claimant. I have carefully perused the letter of 21st day of May 2018. It was addressed to the claimant and its title is Letter of Acknowledgement of Recognizing the Claimant as a bona fide member of Pengasan. The letter does the letter looks like original. I will admit in the circumstances, I will admit some in the evidence as it is relevant to the proceeding before the court, but its evidential value will be assessed at the appropriate time. Therefore, this letter is admitted as Exhibit 17, C17. For the photocopy of letter dated 22nd day of July 2018, titled Respite Police Case Implementation of Supreme Court Judgment Ultimatum to Recall all unduly sacked. In objecting to the admissibility of this document, counsel submitted that it is a photocopy and was not addressed to the claimant, as it was written to one comrade Odu Doma. In response, counsel for the claimant submitted that the document is admissible because it is relevant to the proceedings before the court. It was pleaded. A notice to produce the original was given to the defendant, but they failed and refused to comply. I have examined this document. It is a letter concerning ultimatum given for recall of sacked employee, and the claimant is not complaining of having been sacked from work. In the circumstances, the letter is not relevant to this. Is not relevant, and same is hereby rejected. It is hereby marked, tendered, and rejected. The next document is the document titled Salary Allowances Categorized Corruption, Categorized Computation Benefit of Effiong Apengide, October 23, 1996 to July 13, 2018, 21 years, 10 months. In his response to the objection of admissibility of this document, counsel for the claimant submitted that it is original, relevant, and pleaded. This document being relevant to the proceeding is admissible, but the weight to be attached to it will also be assessed at the appropriate time. In the circumstances, the computation of claimant's entitlement is hereby admitted in evidence and marked as Exhibit C18. On document AAOA, application to rent for counsel for the dependent, this document and the attached JSM lease agreement on the face were altered and forged, and in addition, opened Section 37B of the Evidence Act as the document amount to documentary hearsay. Counsel contended that fraud is the act of creating, altering, or using false or genuine document with the intent to deceive or pass specific control, with the intent of selling it as an aggregating factor. A cursory look at the said document on the page will reveal that the claimant clearly altered the said document. The document is said being a Copyright Act of 2019, which is visible on the bottom page of the document, means that the document itself was produced in 2019. The claimant only downloaded it and superimposed on the event of 2012. The court is vested with power, according to counsel, the court is vested with power at this state to reject them. What the claimant has succeeded in doing is altering the document, which is not acceptable in law, and the right things to be done with such document is to be rejected. Counsel continue his submission that you cannot write into the future, that is 2012, the claimant would be writing on a document produced and printed in 2019 with a Copyright Act watermark, which would mean at that time going 7 years into the future. The documents also being photocopies are inadmissible, and the claimant has failed to lay foundation as to whereabouts of the original document. Counsel asked the court to reject the documents. In support of this submission, counsel relied on the case of Okonko versus Dakolo, where it was held that to tamper with a document has effect of rendering the document unreliable. On the due payment reminder and attached invoices for all the purpose remain an invoice according to counsel and not a receipt of payment. The claimant has not been able to provide any credible evidence to show that he made any payment, as there is no receipt showing proof of payment in court. And among the documents the claimant sought to tender, what constitutes payment in law is the receipt of payment and the receiver of the money coming to testify in court in what mode and manner he or she receives the money and speak to the authenticity of the receipt he or she issued. Counsel asked the court to reject the document. On the document titled Emergency Physician Statement and the attached reminder of due statement and medical reports, counsel submitted that this document would also reveal that the print dates at the top of the document titled Patient's Authorization were printed on 2nd day of July 2014. However, it is surprising and shocking that the claimant also altered same superimposing 2013 event, and his signature was signed on the same document on 12th of November 2013 for a document which was printed on the 2nd day of July 2014. The claimant has shown in many ways to have altered document and forged same. A further look at subsequent pages would reveal that though the documents on the face of it were printed in 2014, 2013 events were recorded on same. This fabrication and alteration, according to counsel, is even visible to the blind. And holding to the contrary will amount to glaring flagrant disrespect for the rule of admissibility of evidence. Counsel relied on the case of Bobio versus Weroba and another to support his submissions on tampering with document which means changing the originality of the document. According to counsel, a second look at the documents and the attachment will reveal that claimant only went online to print document, altered and mutilated them, and forged to advert his mind and did not advert his mind to copyright and dates. The document will reveal that some pages are missing, and the claimant only hurriedly downloaded the pages he felt he needed and the relevant to him. It is submitted that the claimant, having altered this document, which need further proof as they are glaring on the face of it, the document should be rejected. Counsel also submitted that the marker of the maker of the medical report, being a medical practitioner, ought to have been called as a witness to tender same and speak to the authenticity of the medical reports. Counsel asked the court to hold that the medical reports are to be tendered by the doctor who carried out the test and can speak to the content of the document. The claimant, having failed to call the maker of the document, only amount to documentary hearsay, which is in law not admissible. On what amount to documentary hearsay, counsel relied on the case of Maku versus State, where the Court of Appeal held that a document amount to documentary hearsay when the person who purported to have made or signed the document is not the one tendering the document in court. For counsel for the claimant, he submitted that in paragraph 6.17 of the claimant's final written address that the documents referred to as medical bills of the claimant are admissible because the documents have been pleaded in paragraph 11, 12, and 23 of the amended statement of fact. The documents are relevant and also admissible in law. Counsel submitted that the defendant was given notice to produce the original of the medical document but failed to produce same. Counsel further submitted that the date documents were printed does not amount to forgery. The documents have different dates. The residential apartment lease carries different dates from 2012 to 2015, while the document labeled AAOA 2019 also carries different dates. The date documents were printed does not mean that the documents were forged. Apart from the date of the documents were printed, the defendant has not established a case of forgery. Counsel asked the court to, in the absence of proper objection to the admissibility of medical bills of the claimant, admit same and relied on them. On the submissions of the defendants that the medical doctor who made the document ought to have been called as witness to tender same and speak to the authenticity of the medical report. It is not mandatory that a medical practitioner who signed the document or medical report must be called as a witness. In support of this submission, counsel relied on the case of Maazu versus the state. In the case, the defendant did not dispute signature of medical officer calling the medical officer in is not compulsory. I have perused the documents in contention. I start with the document AAO application to rent. This document was meant to show the claimant did apply to rent residential accommodation. As pointed out by the counsel for the claimant, which is glaring, the document was produced or made in 2019, while the event in it was meant to record, while the event recorded on it was the event of 2012. The question to be asked here is, can a document not in existence in 2012, which is to be produced in future, be used for an event in 2012 when it was yet to come into existence? The simple answer is capital no. As such happening is not possible. A further look at page 2 of this document will show that the document was undated. This has also compounded the problem of the document and rendered it inadmissible. In the circumstances, the document is hereby rejected and same is hereby marked tendered and rejected. On the residential apartment lease, it is a photocopy and not original, but is relevant to the proceeding in the circumstances. I admit it in the evidence, but evidential value will be assessed at appropriate time in the course of the judgment. The document is marked as XBC 19. On patient authorization, this document is a photocopy. A cursory look at the document will show that it is a 17-page document, but the pages the claimant want to tender in evidence are pages 4, 7, 10, and 12. There is also another page stapled together with these pages, which is not part of the 17 pages the document was meant to be. Furthermore, as argued by counsel for the claimant, this document suffered same fate with the application to rent in that the date it was printed was on 2nd day of July 2014, while the event recorded in it was the event of 2013. This shows that being an incomplete document, it is not admissible in law, and same is hereby rejected and accordingly marked, tendered, or rejected. On the report on these alleged problems, this document is meant to be a 3-page document, but only 2 pages of the 3 documents were tendered, where the whereabouts of page 1 is unknown and not accounted for. The document being incomplete is hereby rejected and marked accordingly. On emergency position statement, this document is a bundle of documents. Some were 2 pages, but only one page were tendered, where the whereabouts of page 2 is not made known, has not been made known, and there was no explanation regarding the missing pages. I also note the documents were electronically generated. This makes their admissibility subject to the provisions of Section 84 of the Evidence Act as amended. In view of the fact that the documents are incomplete and not in compliance with Section 84 of the Evidence Act, I hereby reject them and mark them accordingly tendered and rejected. On the 2 invoices and 1 receipt, the defendant objected to the admissibility of this document. I have carefully considered the document. I am of the view that being tendered to show expenses incurred by the claimant, which he is seeking for refund, they are relevant, but the weight to be attached to them will be assessed at the appropriate time. I hereby admit them in evidence and mark as Exhibit C20. The invoice of November 2012 to July 15, 2016 is admitted in evidence and marked as Exhibit C20. The other invoice dated from November 1st, 2012 to July 15, 2016 is admitted in evidence and marked as Exhibit C21. For the receipt by Nilha Home Nursing Therapy Services is admitted in evidence and marked as Exhibit C22. Having determined the admissibility of the remaining having determined the admissibility of the document to which ruling on the admissibility was reserved till today, I shall now proceed to determine the substantive suit of the claimant. By virtue of Section 131, 132, 133 of the Evidence Act, a party's own legal duty, evidential burden of proving assertion he makes. He who asserts must prove. In the instant case, the claimant owes the legal duty of proving the assertions he made against the defendant, on the basis of which he wants this court to give him want this court to enter judgment in his favor. See the case of Mogaji versus Odofin. See Chiamaka versus Osakwe, Adegoke versus Adibi, Diaz versus Bamboshe, Egareva versus Osagi, Opombo versus APC. The reliefs being sought by the claimants are well set out in the earlier part of this judgment. There are 8 reliefs. Reliefs 1, 2, 3, 4 are seeking for declarations, while reliefs 5, 6, 7, and 8 are praying for damages and litigation costs. For reliefs 1, 2, 3, 4 seeking for declarations, the law is well settled that claimant who seek declaratory reliefs from the court must in all cases rely on the strength of his own case by production of credible and sufficient evidence which establishes entitlement to the declaration sought before he could seek to rely on part of the defendant's case, if any, that support his declaration, if any. Such claimant cannot, however, rely solely either on admission or weakness of the defendant case for the declaration. In the instant case, counsel for the claimant has made heavy whether on unchallenged and contradicted evidence that alone cannot grant success in securing grant of declarations. As the claimant must adduce credible evidence to prove that he is employee of the defendant and prove terms and conditions of his employment based on which he is seeking for declarations and monetary payment. The claimant is duty bound to convince the court that his contract of employment exists. See Bello versus Ueka, see Adigum versus Attorney General of Oyo, see Akande versus Adisa, see Director SSS versus Abakoba, and host of other cases cited therein. The law is also right that claim for salaries and other entitlement are claim for special damages, which by law the claimant must specially plead, particularize, and strictly prove. And the law on this is reflected. See NNPC versus Clipco, Nigeria Limited. See also NECA BB Manufacturing Company Limited versus African Continental Bank. See also UTA versus Gulf Securities Nigeria Limited. See also AG Limited versus Ibrahim. See LUTC Nigeria PLC versus Samuel Peters, where the Supreme Court said ordinarily the law is clear that special damages must not only be specially pleaded, they must be strictly proved by credible evidence of particular losses. See Luke versus Onyero, see Onyero versus Onyero, see also Okafo and others versus Obio. Reliefs 5, 6, 7, and 8 are ancillary claims dependent on the grant of reliefs 1, 2, 3, 4, which are the main reliefs being sought by the claimant from the court. Apart from the insistence of the claimant that the defendant has not challenged the evidence of the claimant, counsel for the claimant has also harped on exhibits C2, C10, C12, C13, C14, C15, C16, and C17 before the court in proof of the claim before the court. The claimant also relied on the decision of the Supreme Court in the case of Mobile Producing Unlimited versus Ocon Johnson and others. The defendant on its part maintained that the claimant is not her employee. He is a spy police posted to serve at its facility. And when the claimant absented himself from duty, he had been disciplined by the Commissioner of Police River State Command and was accordingly dismissed from service. In support of the position canvassed by the defendant, the defendant relied on Exhibit D3, D4, D5, and D6. I have scrutinized the evidence of exhibits relied on by the parties to support their respective position. What is clear to me is the fact that the claimant is one of the employees employed by spy police as spy police officer in the security department of the defendant. The exhibit tendered by the claimant and the defendant all pointed to the fact that claimant was employed by the defendant as spy police. See exhibit C2, C10, C12, C13, C14, C15, and C16. See the corroborative evidence in exhibit D3, D5, D3, D4, D5, and D6 tendered by the defendant. Despite these glaring exhibits, the defendant stoutly denied claimant not being its employee, but DW1 in his evidence agrees that the training attended by the claimant was sponsored by the defendant and it was paid for. He also admitted issuance of Exhibit 12, but insisted it is only for access, but the document speaks for itself. The claimant received commendation letters for excellent performance from the dependent. All these were admitted by the dependent. All this goes to support the claim of the claimant that he is an employee of the dependent. The claimant's case, the claimant claims being employee of the dependent is settled in the decision of the Supreme Court in the case of Mobile Oil Producing Unlimited versus Okonjo and Supra. The dependent relied on Exhibit D5 to support their claim that the claimant was not his employee and portrayed him as absentee when it has also recognized that he fell sick. He fell sick and submitted medical report to excuse him for some days to be away from duty. To make the case of the dependent worse, there was no letter of termination tendered, letter of termination or dismissal tendered before the court to support their assertion that the claimant has been dismissed. On Exhibit 17, it is said to be original letter of acknowledgement. However, a careful examination of the letter will cast doubt in the mind as to its veracity of coming from the dependent. The reason being that the signature does not seem to be original. The finding has clearly placed a cloak on the veracity of this document. In the circumstances, Exhibit C-17 command no evidential value. And same is hereby discountenanced for the purpose of this judgment. Therefore, it is my finding that the claimant is still employee of the defendant, as there is no evidence of termination or dismissal. I now turn to whether the claimant has proved entitlement to payment of his salaries for 21 years, 10 months. In proof of his claim for salaries, the claimant relied on Exhibit 18. I note that this exhibit was prepared as a behest of the claimant. I also note that Exhibit C2, I also note that CW2, who prepared Exhibit C18, is not a staff of the defendant in its account department. C2 in paragraph 3, 4, 5, 6 of the witness statement on oath has stated that he was engaged by the claimant to compute his salaries and allowances and financial benefit as per his conditions of service with Mobile Producing Nigeria Unlimited from 23rd day of October 1996 to July 2018. To execute the assignment, CW2 was handed over, to execute the assignment, certain documents were handed over to CW2, which are the claimant's letter of appointment, Exhibit C15, working agreement with Mobile Producing Nigeria and Unlimited, miscellaneous employment conditions and documents of his medical expenses to enable him prepare his financial entitlement. He followed the schedule of salary and the entitlement of other staff of Mobile Producing Nigeria Unlimited in the same class with the claimant. The claimant, under cross-examination, stated that the computation by chartered accountant was based on the Supreme Court judgment and he used least staff entitlement in mobile producing unlimited. Also, mobile working agreement was used and new staff employee conditions of service. He cannot remember his colleagues whom he was employed with. The evidence of CW2 is that he stated as stated in his paragraph 3 and 4 of the claimant of the statement on oath, witness statement on oath, that the documents were given to him. It was based on this document given to him that he calculated the entitlement, but he does not have the document in court. It is clear to me that Exhibit C15, the letter of appointment of the claimant, is silent on terms and conditions of service, and the working agreement tendered was rejected. This means there is no terms and conditions of service used in computation of entitlement, as those documents were rejected by the court. In the circumstances, Exhibit C18 lacks evidential value. Is a worthless document that cannot be relied upon to assess or to determine the entitlement of the claimant, since the collective agreement based on which they were prepared were rejected. And even if the collective agreement were admitted in evidence, they have a limited number of years. One is for a period of 3 years and the other is for a period of 1 year. So for a salary of 20, for the salary and entitlement of 21 years, you cannot use the document that only operate for 4 years for the entitlement. This also means the calculation of the entitlement of the claimant, his salaries and other allowances was based on a guesswork. In any event, in a claim for salary, for arrears of salaries, the claimant is required by law to prove that he is an employee of the employer, and the employer appointed him on a particular salary and he worked for the period of claim. See the case of Bonica Sawmill Nigeria Limited versus Hope, where it was held by the Court of Appeal, I quote, as between an employer and employee, the onus is on the employee to prove that the employer employed him on a stipulated salary and that he worked for the employer during the relevant period of the claim. It is when an employee has discharged this burden that onus of proof will now be on the employer to prove that not only that he paid the employee his salary for work done by the employee in the relevant period, but also how much the salary was which he paid the employee. In the case at hand, there was no proof by the claimant that he worked for the period of the claim. It is to be noted payment of wages is only for work done. See Olatu Bosun versus NISA. See also Nwafo versus Attorney General of Anambra State. I now consider the entitlement of the claimant to refund of medical expenses incurred abroad in USA. The claim for entitlement of employee is by instrument comparing the entitlement on the employee, because entitlements are earned. In the cases of employment, entitlement to health medical claim is a function of the terms and conditions of service. In the case at hand, the claimant has not pointed out any provisions of the terms and conditions of service entitling him to the refund of medical bills without the claimant pinning down his claim to any particular provision contained in the terms and conditions of service. He will not be able to succeed in his claim. Another debilitating and militating factor respecting or surrounding the claimant's claim for refund of medical expenses is the absence of credible admissible evidence in proof of the claim. As earlier pointed out in this judgment, the quality of the evidence adduced is not capable of proving special damages, as the document relied by the claimant are caricature of evidence capable of establishing, not capable of establishing special damages claim. Another devastating evidence that worked, another devastating factor that worked against the grant of the grant of the refund of the expenses of the said expenses to have been incurred by the claimant is his medical trip to US is Exhibit 13, the ECOWAS passport. The claimant alleged to have used Exhibit 13 for the trip to USA. But surprisingly, the said Exhibit 13 bears the name of different person from the name of the claimant. The medical reports and the bill standard and the lease agreement bears the name that does not belong to the claimant. Exhibit C13 was procured on 7th day of August 2012 and expired on the 6th of August 2017. So if it is true that the claimant has changed his name in 2008 as per his Exhibit C8 and newspaper publication Exhibit 11 and his pleading, then how comes the claimant who claimed to have changed his name by this exhibit procured Exhibit 13 in 2012 with the name that he said he has changed? What is this portrayed is that there is something fishy, or somebody is bearing the name on Exhibit C13 and not the claimant, because as at the time Exhibit 13 was acquired in 2012, the name of the claimant has changed to Effiong Apangide and not Joshua Isong Apangide. The discrepancy or the differences in the name goes to show that the claimant was not the one who traveled to the United States for medical treatment. This has dented the evidence of the claimant and rendered it unreliable. Therefore, I have no choice than to reject all the evidences adduced in respect thereof as unreliable. Also, some of the documents on the medical claim tendered by the claimant are either incomplete documents or doubtful due to the tempering or superimposition to use the counsel for the claimant's language. In law, evidence of a witness is regarded contradictory when gives inconsistent account of same event. The contradiction to be shared proceeding, there must be materials and substantial. In the case at hand, the claimant has in his pleading an exhibit tendered before the court shows that he has completely changed his name. He is no longer bearing Joshua Isong Apangide, and his name that he is bearing as at the time when Exhibit 13 was procured is Apangide. Is Epion Apangide. Therefore, there is contradiction in the evidence of the claimant regarding his name. As he has told this court, he has changed his name, but he went and procured a passport with the same name that he claimed to have changed. Another angle to the claim of the claimant on report of medical trip to US is that those claims are caught by the statute of limitation. Though this issue has not been raised by any of the parties, the court is entitled to raise it, being an issue that affects the jurisdiction of the court. The law requires institution of an action on tort to be brought within 5 years from the date of accrual of the cause of action. In this case, the claimant did not institute his action within the time allowed by Section 36 of the General Limitation Law that has pegged period of 5 years. From the evidence from the record of the court, the claimant cause of action arose in April 2012 when he was diagnosed with hydrocarbon pollution substance poisonous attack after leaving his work location at the Dependence BRT hydrocarbon gas plant facilities at Bonny Island. See Exhibit 11 of the amended statement of facts. Paragraph 11 of the amended statement of fact. While this action was instituted on the second day of November 2020, this clearly shows that the claimant instituted this action well over a period of 5 years, which is not allowed in law as per the limitation law. All I have been saying above is that the claimant has failed to establish his case. The failure of reliefs 1, 2, 3, 4 means failure of the other reliefs which are ancillary to the claim of the claimant. Before drawing the curtain of this judgment, let me express my displeasure with counsel for the defendant for using the medium of his final written address to castigate the defendant's witness by tagging him as forger of document. Counsel insinuated that the claimant tampered with exhibit before the court, that allegation is untrue and should not have come from counsel. It is to be noted that the responsibility of marking of exhibit has, by the rules of this court, been laid on the shoulders of the registrar or clerk of the court, and not that of counsel. After all the documents tendered before the court were in the custody of the court and not in the custody of the claimant or his witnesses. And when Exhibit G was shown to witness under cross-examination, which is the document that was wrongly marked, the court took pains in the presence of the counsel in court to read out the record of proceeding of 29th day of March 2022, the date when the documents tendered and sorted out the mistake made in the marking of the exhibit. Counsel should always be cautious when uttering words in court, or in his written address, to avoid wrong labeling of counsel or witnesses in a case. I say no more on this. From all I have been saying above, the claimant in this case has woefully failed to prove his case by preponderance of evidence. The case is hereby has failed to prove his case by preponderance of evidence. Another issue that was not raised by the parties concerning the salary claim of the claimant is that the claim of salary from 1996 to when the case in Ocon Johnson versus Mobile Oil Producing Unlimited, which the court went on appeal to the Court of Appeal. The Court of Appeal has clearly and unequivocally dismissed the claims on salaries and entitlement as for lack of proof. And this decision was affirmed by the Supreme Court decision in Mobile Producing Unlimited versus Ocon Johnson, which the claimant himself relied to establish that he is a party in this case. Therefore, all the claims of salaries from 1996 till when the judgment of the Supreme Court was given have been dealt with in the case of Mobile Oil Producing Unlimited versus Ocon Johnson. And the claimant who was represented in that case is bound by the decision of the Court of Appeal and the Supreme Court and is stopped from raising that issue in the present case. From all I have been saying above, the claimant has woefully failed to prove his case by preponderance of evidence. The case of the claimant having not been proved is hereby dismissed for being frivolous and vexatious. I make no order as to cost. Parties to bear their respective cost. Judgment is hereby entered accordingly.
As God pleases. We're most grateful, my Lord, for the well-resound judgments. We're grateful to the court. My Lord has already said, he's not making an order to cost, and we are bound by it. However, I would have said we have expended a lot of time for the claimant to bring us to court and filing a frivolous action. We must be
closed. We wish my comfort officials on that.
That's very true, my Lord. We wish my Lord a very happy holiday. My Lord,
thank you. I wish you the same.
Thank you, my Lord. We are grateful.
I wish you the same. Okay, you are welcome.
Thank you,
we have come, counsel. We have come to the end of today's proceeding. The administrator, you can discontinue with the sitting. The court will rise.
Wow.